For this episode of Scholar Talks, we will be discussing why the constitutional principle of the separation of powers is part of a dynamic political system. Thomas Bell, our guest, is an associate professor of political science at Knox College, where he teaches constitutional law and American political institutions. He's the author of The Constitution of Conflict: How the Supreme Court Undermines the Separation of Powers, which is today's topic. I am Tony Williams, Senior Fellow at the Bill of Rights Institute, and I want to welcome you to another episode of Scholar Talks in our America 250 series. Thomas, I want to thank you very much for joining us.
Yeah, I'm really glad to be with you. Thanks for having me on.
Yeah, thanks. I love your book, another home run by University of Kansas Press. They found another great author to publish books. And, what I loved about it is this. I learned so much from reading your book, and it also challenged a lot of my views. It challenged my presuppositions, some of my views about politics and constitutionalism and so forth. And I love that, right? I mean, after all, that is the reason why we read books and discuss ideas.
Wonderful. I'm really glad to hear that. I had a good time writing the book, and definitely, I think it is kind of a reconsideration of the nature of American government. It kind of takes us away from our court-centered view of the way American politics works. And so I'm really glad to be here to talk about it with you and to kind of explore the thesis and the different case studies that I explore with that framework.
Great. Well, let's dive right in. Okay, so you argue generally that the Supreme Court should not be the major enforcer of the separation of powers. Why not?
Yeah, it really is the central question of the book, right? In the subtitle that the Supreme Court undermines the separation of powers. I think the short answer, which I'll expand upon, is that the notion that the court should decide the separation of powers disputes between Congress and the president misconceives what the nature of the Constitution is. The court, and I would venture to say most Americans, certainly legal scholars, conceive of the Constitution primarily as a legal document, and therefore as a legal document, courts in particular, lawyers, jurists, have preeminent interpretive status in determining what the Constitution means. In ways that I think misunderstand the project of the American Constitution. And so generally speaking, when the court thinks about separation of powers, they fluctuate kind of back and forth between two dominant methodologies, formalism and functionalism. And what I try and show in the book is that both of those approaches, while being considerably different from each other, ultimately do the same thing, and that they enforce the Constitution's limits is kind of an end in itself. And so in formalism, the court wants to determine, what does the text say about the powers that the different branches ought to exercise, and using historical, textual, and originalist analysis, the court tries to settle the meaning of the text in ways that kind of determine when one branch has transgressed the textual limits of the Constitution. When the court embraces a functionalist methodology, the court tends to be far more deferential to the political branches, so long as there's balance maintained between the branches. But even then, what the court is doing is kind of ensuring balance to maintain the separation of powers itself. And while the court often says what it's doing with both of these approaches is protecting liberty, the court always invokes liberty in separation of powers cases. We enforce the separation of powers so that we protect liberty. But liberty protection is always kind of secondary to what the court is actually doing, which is largely just enforcing the text as it understands the text, or the textual separation of powers. And any protection of liberty is really kind of secondary and derivative of that, of what the court is actually doing. And I also argue that, sometimes liberty can be imperiled by enforcing the separation of powers for its own sake in that way. And so the court misconceives the project of separation of powers by seeing it as an end in itself. And so I spent a lot of time in the first chapter trying to say the way that the Constitution framers, the Federalists in particular, understood the separation of powers as a means to ends. That's a system through which we achieve ends that are both politically contingent, but also at considerable odds with each other. And so what the Constitution does is it establishes institutions that through their conflict negotiate the political crises that confront the political community, crises that themselves could never be predicted in advance by a constitutional framer. And so, we tend to think of the Federalist Papers' articulation of separation of powers as kind of culminating in the seminal essay in Federalist 51. So the 47 through 51, thinking about culminating ambition counteracting ambition. And I want to point out one thing there is that there's no mention of the court in Federalist 51.
Sure.
But more importantly, the next half of the Federalist really thinks about structures of power. How do you induce competing perspectives on political questions, but also different functional qualities that are all necessary to good government? You want a Congress that deliberates. You need plurality, but you also need a House and a Senate that deliberate differently with different perspectives on public opinion, because public opinion isn't some monolithic entity. We have short-term and long-term interests, and they conflict with each other. We need energy and dispatch, sometimes even secrecy to accomplish goals, maybe even beyond what the legislature anticipated. And there's not necessarily a legal answer to executive actions that extend beyond the confines of law that can be determined apart from the circumstances that led to those departures. And so I take a lot of my thesis from Federalist 37, which says, the goal of a constitutional designer, separation of powers, isn't to legally demarcate the boundaries between the political branches with precision. And in fact, Madison says in Federalist 37, that's practically impossible, that we could never even begin to do it, to determine what the boundaries are between Congress and the president. The goal of constitutional designers, Madison says, is to mingle competing qualities of good governments in their due proportions. And I always think of it, mingling in their due proportions as a balancing act, that over time we have to continue to think about, how to do that through our institutions. And so the court often thinks we've got to settle the separation of powers, but I think that misunderstands that what the separation of powers is institutions put into cooperation and conflict with each other over time to settle political questions.
Right. Yeah, I was just going to say, I see all your case studies show this very interesting, just dynamic, right? A relationship of the political branches and both cooperation, right? Sort of getting things done, having effective government, achieving constitutional ends, still within the purview of the constitutional powers, but also at times conflict when necessary,
Yes.
to keep each other in check, and that dynamic relationship propels things forward.
Right. And actually, one thing I would add is I think one of the things I try and show in the book is that the court has sometimes, when vindicating the separation of powers or its understanding of the separation of powers, itself become the source of deep political dysfunction. And in
Uh-huh.
fact, the source of some of the controversies that we're having today, where the court has maybe kneecapped Congress 50 years ago by depriving it of tools that it says violate the separation of powers, which then mean it's hard for Congress to actually exercise any independent political will against the president in politics today. And it can be hard to see that larger frame when you're
Mhm.
looking at a particular instance. Take the tariff case, for example,
Mhm.
where people went to court and saw the court as the vindicator of congressional prerogatives, not recognizing that actually the court 50 years prior had deprived Congress of its most meaningful tool over the delegation of tariff authority.
Mhm. Mhm. Right. Excellent. Well, let's dive into some of those case studies
Sure.
to illustrate the main point. And so what is a legislative veto? Maybe not a lot of viewers are familiar with that. So, what is a legislative veto in a nutshell, and why was it part of this vibrant separation of powers relationship between Congress and the president?
Yeah, I mean, my chapter on the legislative veto is, I think, probably my favorite chapter of the
Yeah.
book, and I think it's because it deals with this case that actually I think has had perhaps the most extraordinary impact on the structure and functioning of the American government today. Um, um, a legislative veto is really a congressional response to the problem of delegation. And so you can frame the question this way. There's a lot of talk about delegation today, that when Congress gives away its authority to the president or to bureaucratic agencies, that it's giving away power to non-democratic or less democratically accountable entities, and undermining Congress's deliberative and democratic function in the constitutional order. And so certainly that, you think of the non-delegation doctrine in the Schechter case, and the major questions doctrine today, that there's this real concern that if Congress gives away its power, then we don't really live in a republic anymore. And what I want to say is delegation, the non-delegation doctrine has a political insight that is really important in the way I just articulated, but maybe not as a judicial doctrine. And what the legislative veto was when Congress delegated power to the executive branch or administrative agencies, rulemaking power, it retained the ability to say yes or no to specific exercises of that rulemaking power. Okay. And so what it basically does is reverse the order of interbranch action. You have an authorizing statute that delegates power subject to, a concurrent resolution of approval or disapproval, or maybe even a simple resolution of approval or disapproval, so that Congress is ultimately in control. And you can imagine that legislative vetoes, even if they're not used much, just like the president's veto power, means that they have a lot of leverage in the formulation of rules and regulations. And so this was a really important negotiation between Congress and the president to, Congress having a hard time getting things done. The scale of issues on the governing agenda today is massive. If we're going to accomplish goals that we have, it's likely Congress really can't, just given its scope. But also, Congress is a body of generalists, not necessarily experts. So we delegate authority, but we maintain control. And what happened is the court actually invalidated the legislative veto and saw it as kind of a congressional usurpation of executive power. This is an example of Congress running roughshod over the president. And there were books at the time called The Fettered Presidency, for example, that really used the legislative veto as their case. And the big question for me is, why is the court viewing the legislative veto as Congress running roughshod over the president, when what's really happening is Congress is giving away a lot of its power to the president, and then retaining a much smaller role for itself on the backside of legislation. And what the court did in INS versus Chadha, which is this very important and famous case, is say that once Congress delegates legislative power, it becomes executive power by the mere fact that that power is wielded by an executive branch official. And so the court has this unargued presumption that when any branch acts, it exercises the power delegated to it by the Constitution. That's an unargued presumption. And it's just the starting premise for the court that it doesn't even defend. And in fact, in a footnote in the majority opinion, Chief Justice Berger responds to Justice Byron White's dissent, where White had said, well, executive branch officials using rulemaking authority issue those rules without going through bicameralism and presentment. And the majority opinion says, well, the Constitution doesn't require executive branch officials to do that when they act. It's just brushed away. That case is challenging because it actually dealt with an issue that I think was unconstitutional, which was a deportation proceeding. Congress had delegated to the Attorney General the ability to suspend deportation proceedings and then subject to a legislative veto. And I think that's easily distinguishable as a quasi-judicial action. That is, I don't think Congress passing a law and the president signing it could deport an individual. And so it's not even a legislative veto, because even the constitutional requirements for lawmaking aren't sufficient to make that constitutional. But it's had major impacts on Congress's ability to over to both accomplish goals while maintaining democratic oversight. And so I mentioned the tariff example earlier. It's a great example of the tariff statutes, IEPA, originally had a legislative veto, which was invalidated by the court. And so when the president issued changed tariff rates pursuant to that statute, Congress would have to pass legislation that would require supermajorities in both houses to avoid the president's veto. And so you can see it just kneecaps Congress's ability to say no, especially given the partisan incentive structure, the partisan breakdowns today with narrow majorities in Congress.
Right. So it's actually, yeah, undermined this separation of powers, which is your argument.
Yeah.
Yeah. Yeah.
And I think that's of all my case studies, that's the one that I think really has had dramatic implications for contemporary politics. That I would love the court to overturn Chadha. I have a hard time seeing that happening.
Okay. Right. Well, let's move on to something else that you helped change my mind on. So why are executive agreements, which I thought, and I will say some people seem, also think that they seem like kind of a runaround around the treaty power because they're, the treaty making involves supermajorities, whereas an executive agreement is simple majority. So how does an executive agreement still support the separation of powers?
Yeah, it's a great question. And so the premise of the case study chapter is, well, the Constitution only gives us one textual mechanism for international agreements, the treaty, which, negotiated entered into by the president with the advice and consent of 2/3 of the Senate. Certainly, a lot of people think that the 2/3 requirement basically makes it impossible to enter international agreements. There's been a long time push to kind of have executive agreements that just require majorities of both houses. What I show is that what seems controversial isn't really when you think about executive agreements in context. And that context is the scope of the United States involvement in international affairs. The president has the treaty-making power precisely because the president has the ability to move and act, to engage in negotiations, sometimes secretly, in ways that enable proper functioning in the foreign realm. But the reality is that when you think about executive agreements in practice, the vast majority of executive agreements are pursuant to delegations of power. So Congress actually delegates power to enter into agreements to do certain things. So think foreign aid, for example, which, as far as I can tell, the vast majority of executive agreements are things related to things like foreign aid. And insofar as Congress consistently appropriates and creates these statutory authorizations, Congress, at least in theory, is able to exercise a lot of control over the way the president uses that power. In fact, a scholar in the 80s showed that oftentimes broad-based delegations demonstrated a lot of agreement between the two branches and how that power is being negotiated. And when there was disagreement, Congress created much narrower delegations. This is at least in theory. Another scholar, Gary Smet, who did a lot of work on military executive agreements in the 80s, showed that executive agreements is really a misnomer given how much Congress, through appropriations and oversight, was deeply engaged in the substance of our foreign commitments. And so the main argument that I make in that chapter is that given the executive branch's unique institutional strength, it's not surprising that as our international obligations have dramatically increased, that international agreements have primarily become executive agreements. What I argue is that ultimately what matters is, well, are significant agreements done as treaties? Does Congress do a nice job of both overseeing its delegated powers, but also insisting that certain issue areas are so important that it ought to be done as a treaty? And for a lot of our history, I think that really was borne out. I will note that one of the challenges of writing this, and a lot of scholars like Jack Goldsmith um, have shown, and I ran into this problem when I was researching because I tried to actually go through and start finding agreements and their legal authorizations, and these things were really impossible to find. And Congress has done a lot of work now to rectify that problem. There was really an informational gap. How does Congress wasn't even aware of a lot of agreements, and they've rectified that problem recently. I don't know what the status of that is, but they definitely passed new legislation to require an informational record. The one, I spent a lot of time talking about the Iran agreement. I think that's a really good example of Congress actually, the president actually was purely had legal authority to waive sanctions against Iran based on delegated authorities he already had. And Congress said, well, even if you have that power, you're changing our foreign policy significantly. And so we should have a say. And you really, the Iran Agreement Review Act that Congress passed was a significant expression of congressional power, but ultimately done so, I argue in the book, in a way that inverted the treaty process, because what they did was say, we need a joint resolution of disapproval, which means only it can go in effect with only 1/3 of Congress supporting it. And which the argument I made was that means members of Congress can vote no, knowing that a no vote has no meaningful consequences. So you can actually in private support it and vote no for political reasons, but not actually deliberate on the actual stakes. And so the point of the chapter is to say you've really got to think about the political dimensions of executive agreements, that if you only focus on the treaty clause itself, you miss the ways that Congress exercises political capacities well beyond what you see if you focus on the text itself.
So, last case study, and how has congressional investigation, especially the impeachment power, strengthened the separation of powers?
Yeah, this was the last case study I wrote, and I wrote it right after the second impeachment of President Trump. And the main kind of argument of that chapter is, given the architectural view that I articulate in the book, Congress gives a lot of power to the president, and the president has a lot of outsized powers, and some of those powers are kind of prefigured in the constitutional design. That energy, dispatch, able to meet challenges not anticipated by standing law, are all kind of built into the separation of power system as I understand it. But if presidential power grows as the needs of the nation expand and presidential power needs to grow to meet them, Congress's powers have to grow as well in kind of an evaluative and kind of post hoc sense, which is to say Congress investigation impeachment. That the president might move first, but Congress ultimately has the last word in evaluating presidential conduct by being able to actually fire and remove from office the president. And so what I do is I look at kind of 3 different dimensions of congressional oversight and show how legalistic understandings of those powers have undermined Congress in the long term. So for example, I look at executive privilege, Congress's subpoena power. Should Congress go to court to enforce its own subpoenas? And what I show is, there might be valid reasons for the presidents to keep information from Congress. Those secrecy is circumstantially contingent, though. Is the secret you're keeping from Congress being kept for a good reason? And what's happened over time, especially with the President's Office of Legal Counsel, is they've understood executive privilege as an inherent right of the presidency that must be protected. So presidents today don't even invoke executive privilege often. They say we can't answer that question because we need to protect the president's ability to invoke executive privilege later on. And as Congress then goes to courts to enforce its subpoenas, it takes forever. Oftentimes it's no longer politically relevant. A new Congress is seated. But more fundamentally, it acts like there's a legal answer to the question when whether or not something ought to be secret or not is a political question. And then I look at impeachment. the, most scholars, I think, understand that impeachment extends beyond indictable offenses or crimes to political offenses, abuses of power. But in political practice, it's largely only been exercised for violations of the law. And
Hmm.
what I think is that ultimately that makes it impossible for Congress to control abuses of power, to have political disagreements with the president. And you saw that in both of the impeachments of the president. So in the first impeachment, was it a quid pro quo or not? And we've got to look at the legal question. And the president's lawyers ultimately argued, well, it wasn't a crime, so it's not impeachable. So even if the call took place, even if the factual record is accurate, it's not an impeachable offense. And that was then the basis of the Senate resolution with Republicans acquitting the president. But even Democrats, they were motivated to impeach not by just the quid pro quo. There was a lot of larger context, the way the president used his powers and abused his powers, that provided greater context. And the quid pro quo became, we found the open and shut legalistic case. And they were constrained by these larger political conceptions of impeachment that made it harder for them to make a political case about why the president needed to be removed from office. And you saw the same thing in the second impeachment. Was incitement, was he protected by the First Amendment? Not whether or not the incitement was an abuse of power that required impeachment and even post hoc, post presidency removal and disqualification. And in the last section, I say, the move to punish political transgressions through criminal prosecution. And I certainly make the argument, I understand why prosecution was essential once all the other political remedies weren't used, but the Congress's own abandonment of its own powers or narrow conceptions of its powers left us in this horrible situation where the only way to punish the president's lawlessness was through prosecutions, which is always going to raise substantial challenges for a political community.
Right. So you're saying if Congress sees its own powers as only being able to impeach a president for actual crimes rather than misdeeds in office, then it's really limiting that very strong constitutional political ability to, in the separation of powers, to push back on the presidency or the Supreme Court.
Right. Well, in one way you might think about it, if impeachment's a viable tool of Congress, it empowers Congress long before the actual exercise of that power. Kind of like the veto power, for example. If Congress knows where the president's veto point is, they're going to negotiate with the president to move legislation close to the president's preferred position. So I think same with impeachment. If a president knows they could be impeached, Congress is empowered it can use other powers long before impeachment to contest the president politically.
Right. And as you say, it's just in this very dynamic relationship, which leads me actually to my last question. So why don't we jump into that? Why is the constitutional principle of the separation of powers part of a dynamic political system, the contest of the political branches?
Yeah, I mean, by saying the separation of powers dynamic recognizes the way the separation of powers actually works. And so I think the way we tend to think about the separation of powers, we think of it as a legal principle, that it's fixed, and that legal analysis can help us determine the exact limits of governmental power. And that's just not the way that the Federalists talk about the purposes of the Constitution. The constitutions are about achieving ends that we don't know. We don't even know what questions will arise. So how could we script answers? And so to say that what the Constitution does is it sets into motion a dynamic political system that through interaction between the branches helps settle certain questions over time. And that's not to say settles them rightly. That's not to say that there's not deep disagreement in politics about what the limits of the different branches are. But the idea of Federalist 51 is you give members of each branch the means and the motives. And I think that's one of the challenges today. And I articulate this in the book, thinking about hyperpartisanship and the separation of powers. It's really hard to imagine today Congress standing up against a president of their own party. Just think back to the first Trump impeachment. I mean, the second article of impeachment was related to the unprecedented obstruction of Congress's own processes regarding their subpoenas. And that's not really the article of impeachment we talk about, but that's the one that actually the president's arguments basically disempowered Congress from any oversight over the executive branch. And not a single Republican fought for those prerogatives. And so in the book, I think of, what the framers understood, that the way people run for office, who elects them to office, that these all matter for how someone performs in office. And so I think there's a lot of work to be done to think about how members of Congress, who they're accountable to, and ways that would help achieve more majoritarian outcomes and help people think about the common good, more than kind of narrow and extreme constituencies that are the first people they answer to.
Right. Super important point to end on. I love it. So, Thomas Bell, I want to thank you very much for discussing your book on constitutional principles, how appropriate as we celebrate America 250.
I'm really glad to be with you. Thank you.
All right, thank you. And thank you all for joining us on this episode of Scholar Talks in the America 250 series. Check out the other interviews in the series on our channel and click subscribe.